Hey everyone, I'm Ashleigh Banfield, and this is Drop Dead Serious. Here we go. It's on. I know you've been waiting. I have. I've been curious. I've been listening. I've been watching the internet, basically imploding and also exploding. Everybody feels something different because this case has all the feels. But the jury is the most important group of people in the Lindsay Clancy murder trial. And now that jury has heard everything they need to, including two, not one, two different forensic psychiatrists. These people examined the same person, Lindsay Clancy. They got the same medical history. They got the same, bona fides. They got the same, degrees and all the rest. They learned about the same horrific night where she killed her 3 kids using exercise bands. And these two forensic psychiatrists reached completely opposite conclusions. Do what now? So frustrating, but in my line of work, which is watching a million trials, happens all the time. It's called Battle of the Experts. And that's what we got ourselves here in the Lindsay Clancy case. We got a battle of the experts and emotions that runneth over on both sides. So let's start first with the defense, because they called their final witness, and it was Dr. Phillip Resnick. He's the country's most prominent forensic psychiatrist, one of them anyway. He testified that Lindsay Clancy was, quote, frankly psychotic, end quote, when she killed her 3 children. Let's remember who they are, okay? 5-year-old Cora, 3-year-old Dawson, and little baby Callan, just 8 months. 8 months. Look, these kids couldn't fight back. 8 months old, Callan probably wasn't walking, obviously, right? 5 years old, I don't even think a 5-year-old would know what's going on. A 3-year-old definitely wouldn't. This all happened in the basement of Lindsay Clancy's home, the one she shared with her husband in Duxbury, Massachusetts. That doctor I've been talking about, Dr. Resnick, he diagnosed Lindsay with some very important things, and you need to know what these are because they all count when it comes to what the jury has to decide. He said Lindsay had bipolar 2 disorder with severe depression. He acknowledged that the onset of postpartum psychosis 8 months after giving birth would be unusual. We did an episode on that. It usually happens right after, in the days and weeks after a birth. It doesn't often happen 8 months, but it can. And Dr. Resnick testified that it can happen. And it could have happened for Lindsay, that her illness may have had a postpartum onset. So he said the thing that my guest said a few days ago. Yeah, it can happen. Rare? Yes. Does it happen? Yes. He also tried to answer one of the biggest questions that's hanging over the defense's case, and that is if Lindsay was psychotic. Well, then why did so many people around her fail to even notice it? Because you would think if you had someone psychotic in your house, or you were actually treating someone who was psychotic, that, you might see something. But why did her husband leave her alone with the kids if she was psychotic, right? Why did her doctors repeatedly document anxiety, depression, but never psychosis? And how could Lindsay communicate? How could she complete ordinary tasks, appear to be having a relatively good day, before killing all 3 of her children with her own bare hands and exercise bands? It's a good question. And Dr. Resnick's explanation was also good. It was that psychosis does not necessarily look the way it does in the movies. It doesn't look the way people expect it to look. It can come and it can go. And that's what our expert said just a few days ago on one of our episodes. We'll link it in the description. I think it's really, really good. She was so clear in her explanations, and that's what she does for a living. Dr. Resnick said a person can remain capable of speaking and planning and functioning in certain areas of life while at the same time experiencing hallucinations and delusions. Go figure. In his opinion, Lindsay did not need to be visibly psychotic every single minute of January 24th, 2023, when this horror show happened. She didn't need to be in that state every single moment to have been psychotic when she killed the children and then not psychotic after or even before. He testified that Lindsay experienced what's known as a command hallucination. That's a voice directing her to commit a certain act. But according to Dr. Resnick, this was not simply a voice that Lindsay could hear and then choose to ignore. He believes that she was also experiencing a delusion of influence. And that means Lindsay, in his opinion, believed that an outside force had taken control of her body. The doctor described her as feeling like a puppet, with somebody or something either pulling the strings or managing the puppeting. Lindsay reportedly told Dr. Resnick that the voice began commanding her to kill the kids the minute her husband Patrick left the house. And don't forget, she's the one who told her to go. Honey, go get the prescription and then go get dinner at that restaurant that's even further away than the one that's close. Dr. Resnick said that's when Lindsay took the kids to the basement, one at a time, strangled each of them, and then told each of them, quote, "Go to God. Go to God." Yeah, that matters. Go to God is a whole lot different than "you son of a bitch." It's the difference between insane and sane. Can be. Dr. Resnick testified that Lindsay did not believe that she had the ability to resist that command. In his opinion, her mental illness left her unable to conform her conduct to the requirements of the law. Oh, read that again. Ready? Unable to conform her conduct to the requirements of the law. Boy, that sounds a lot like criminal code. Interesting that a doctor would be using the same language as criminal code. I'll get to that in a moment because I've got somebody who's been through a few of these cases before. My guest today is going to explain to you why that, while it sounds absolutely perfect for the defense, because, oh my God, it's actually what the criminal code says they have to prove, and there he is saying it on the stand. And a little bit more. He actually talked about Lindsay's ability to appreciate that her actions were wrong. Because the legal question in this case is whether Lindsay's mental disease or defect left her, say it with me, unable to appreciate that her actions were wrong or unable to control her conduct and obey the law. My guest is coming up in a minute and is going to say, what the actual? That expert, while it sounds maybe perfect, is actually not doing something he should be doing. And the court should have objected. If it wasn't the prosecutor, the judge should have said something. But they didn't, and the jury was left with that. Those words are so specific, and they match exactly what the jury has to consider. Like, perfectly for the defense. It might be because the case matches perfectly what the defense is saying. And if you don't believe that, this expert said it. And I get it. It's a battle of the experts. And the prosecution's expert didn't say it this clearly. But this expert probably shouldn't have said it this clearly. I'll get to that in a minute. Matt is really good at this. Matt Murphy's my guest today. He's going to explain a lot about this case. And by the way, Matt Murphy, as a former homicide prosecutor, I usually know that when I ask him to be a guest, he's going to, be all up in the prosecution's, house. And not today. This is a surprise. I could not believe that Matt told me some of the things he told me. That's coming in a minute, so don't go anywhere. Dr. Resnick didn't believe that Lindsay knew right from wrong or could conform her conduct to the requirements of the law. He just didn't. And he was real clear about it. Too clear. He also classified the killings in two ways. Acutely psychotic and something he called altruistic filicide. I hadn't heard that before. Altruistic filicide. Filicide's when you kill your children. Altruism is nice. So a nice way of killing your children. That doesn't mean that strangling isn't horrible. It is horrible. It was the reason behind it. To be nice. Acutely psychotic filicide describes a parent who kills a child while acting under a hallucination or a delusion without understandable, rational motive, meaning you don't have any reason to kill these kids. They are not eating you alive like a school of piranhas and you got to kill them, self-defense. There's no motive. We're all tired as moms. It's not a motive to kill. Altruistic filicide involves a parent who irrationally believes that killing the child is somehow in the child's best interest. Like Andrea Yates, I am saving them. I am saving these children. keeping them from the devil. The devil's going to get them unless I protect them and get them to God as fast as I can. Altruistic filicide. It's a thing. According to Dr. Resnick, Lindsay believed that her children would be miserable without her if she died. In her distorted state of mind, he said Lindsay believed she was doing them a favor by taking them with her so that they could all be together in heaven. I'm curious, though, why she wouldn't want Patrick to be there, too. So why wasn't it a murder, suicide? Why wasn't this a quadruple murder and a suicide attempt? Nobody's really brought that up. But this doctor said that he thought she wanted to keep them safe with her in heaven. And he testified that Lindsay understood that killing a child would ordinarily be against the law, but that she believed what she was doing was morally right for her kids. Maybe not legally right, but morally right. Dr. Resnick also pointed to Lindsay's suicide attempt that happened right after she killed her 3 kids. And in his opinion, the severity of that attempt, right? How bad it was, she cut herself, drugged herself, and jumped out of the window. The severity of what she did actually supported the conclusion that she genuinely intended to die and was profoundly mentally ill. I know a lot of people have questioned, oh, those are superficial wounds. Oh, she was barely bleeding. And there was testimony that she was cold AF. Her body temperature was so low when she came to the hospital. Maybe that was why she wasn't bleeding right away, and the paramedics didn't really think they had to do much to treat her. But then, oh, oops, later on, she needed stitches. Body temperature may have gone up at the hospital. Blood starts flowing. Oh, dear, this gash is 3 centimeters deep. So this doctor said what she did with the knife, with the jump, everything, it did support that she wanted to die, as opposed to what some people have said, this was a cover-up. But the prosecutors had a few things to say about Dr. Resnick, and they used his own expertise and his writings to challenge him, and actually to challenge just about everything that he said in his conclusions on the stand. The Commonwealth of Massachusetts went after Dr. Resnick, and they used his own published statement to do it. A statement that command auditory hallucinations can be easy to fake. Yeah, command auditory hallucinations can be faked, fabricated. Prosecutors also pointed to warning signs that he himself had identified. The doctor has identified when evaluating whether somebody might be actually faking their hallucinations. And among those warning signs, you ready? Claiming to obey every command and making no effort to resist or diminish those voices. And that's what Lindsay Clancy did. She didn't try to resist these male voices in her head telling her to kill the kids, protect them, kill the kids. She didn't ever say, I didn't want to, I held back for a bit, and then the voices were just too loud. No, she just went with it. And in this doctor's own conclusion, sometimes when they go with everything, that's kind of a sign that it could be fake. The prosecutors also used Dr. Resnick's involvement in Andrea Yates's case to highlight just how different these 2 women's histories were. And here we are a quarter century later, and we're talking about Andrea Yates's case. Plural, cases. If you don't know it, go back, take a look, Google it. She was found guilty in her first trial, and then they found some really bad evidence, like a lie that was told on the stand, and that trial was tossed out. That result was tossed out. She was retried again, and she was found not guilty by reason of insanity, committed to an institution. Quarter century later, she's still there in the institution, does not want to leave. According to the testimony, she'd experienced voices for roughly 2 years. She'd undergone multiple psychiatric hospitalizations and made previous suicide attempts connected to those symptoms. And the Commonwealth of Massachusetts pointed out that Lindsay Clancy did not have comparable documented history of voices, had no previous hospitalizations for psychosis. Yes, she committed herself and went in and said, I think I'm a danger to myself. Never said I'm a danger to the kids. And Lindsay Clancy had no previous suicide attempts tied to hallucination either. That in itself doesn't prove that Lindsay was not psychotic, right? Doesn't get you all the way there, but prosecutors clearly want the jury to question why the most important alleged symptom, psychosis, in the defense's case appeared only after the children were dead, or was talked about only after the children were dead. Well, maybe her medical care sucked. Possible. She had telemedicine. Woo! She had some in-person medicine, but a lot of her testimony that was on the prosecution side from a medical expert who treated her was a telemed who'd never seen her in person. So I can see the jury saying, ew. I can see them questioning how good that medicine was for her, that treatment was. Dr. Resnick also testified that Lindsay generally disclosed her symptoms to her providers, but withheld her thoughts or impulses involving the children because she was afraid the kids would be taken away. That makes sense, right? I could see a mom who's suffering from an array of different mental illnesses, terrified to say something because she doesn't want to lose her kids. She wants help. She doesn't want that help to be take my kids away. So that gives the defense an explanation for why those thoughts didn't show up more clearly in the medical records or before the actual killings happened. The prosecution, though, wants the jury to consider another possibility, that the records don't document psychosis because Lindsay Clancy was not psychotic. That's what the prosecutors want this jury to take away from all the evidence they've seen so far. And then prosecutors turn to Lindsay's condition after the killings. The expert who took the stand for the defense, for Lindsay Clancy, to help her in her case, Dr. Resnick, has written that the unusually rapid disappearance of psychotic symptoms, that could be a warning sign too when evaluating whether someone's symptoms are genuine or phony baloney. So hold it. The prosecution is able to get in cross-examination of the defense's own medical witness who says she was in psychosis. They were able to point out, well, right after the killings, that psychosis really sailed. It was gonzo. And you yourself, doctor, have said if those symptoms go fast, it could be a red flag that it was phony. And according to records discussed in court, Lindsay Clancy has denied experiencing any hallucinations before or after the night she killed her 3 kids. Treatment records reportedly describe her as clinically stable, engaged in treatment, and showing no observable symptoms of psychosis. That's bad for her. That is bad for her lawyer. It is bad for her case. And it is tough for the jury to reconcile with what her medical expert testified to, and some of the things that her own medical expert has written in the past about how to spot a phony. The jury also heard that Lindsay has identified goals for her future, including becoming an advocate for postpartum psychosis awareness and participating in a wheelchair marathon. So, a jail marathon? Or out there with the rest of us? I want out. Eventually, I want out. I want to be back with the flock. And that was the last witness for the defense before the defense rested. The prosecutors immediately called their own psychiatrist, Dr. Avram Mack, who told the jury that he does not believe Lindsay was psychotic at all. Dr. Mack agreed that Lindsay suffered from major depression and anxiety. Postpartum, sure, but he said he found no evidence that she was experiencing mania, hypomania, or psychosis when she decided to strangle her kids hand to hand, right, using exercise bands. Dr. Mack also focused on the sequence of the killings of those kids, describing Lindsay as carrying out an organized one-by-one effort to accomplish a particular goal, a very sinister goal. He also pointed to discrepancies between what Lindsay told him and other evidence, including questions about a locked bedroom door, the window screen, and what the children were doing before Patrick left the house. There were differences in these answers. Does it matter? Will it matter to the jury? Don't know. We'll find out. And this doctor also placed a particular significance on the words that Lindsay allegedly said to the children, quote, "Go to God. Go to God." Dr. Mack believes those words show that Lindsay understood that the children were innocent and understood that the action, what she was about to do, was final. Final. I'm not so sure that that means wrong in her mind if she's psychotic. Maybe it's final because maybe she wanted it to be final. Go to God. You can't go to God if you're alive. His ultimate conclusion, though, was that Lindsay knew right from wrong and retain the ability to follow the law. Those are the prongs, right? You'll hear more about that in a second because it is actually complicated. What the jury has to understand and the boxes they have to check, according to Massachusetts law and the insanity defense is tricky. And I work in true crime. I have for decades, and I still sometimes think, gosh, this is hard. I'm not sure I can put this all together if I have to contemplate weeks of testimony and these 3 questions. It's tricky. So her defense attorney, Kevin Reddington, attacked both Dr. Mack's conclusions and his experience with postpartum psychosis. Dr. Mack estimated that he had treated approximately 10, count them, these fingers right here, 10 women with postpartum psychosis since the year 2001. It's 2026. So a quarter century, a grand total of 10 patients who suffer from this. That's not nothing, but it's pretty small. And if you think that I'm being hyperbolic by saying a grand total of 10 in a quarter century, listen to how Lindsay's defense attorney ripped him a new one while he was on the stand.
Where in here does it say that you ever came within breathing distance of a pregnant woman and your practice and your interest in your writings?
So I remember being at the Brigham as a resident and
How long ago was
going
that?
to, how long ago was that?
Yeah, give us a year.
Well, you asked me when.
Yeah,
So I'm
that's
starting.
when.
That was the memory I have for that particular situation was 2001.
2001, so 25 years ago. Do you know what her readings were on the Edinburgh test?
Not to my memory at the moment, no.
Why not? You read the medical records, didn't you?
I mean, if you would like to show me, I'd
I
be
don't
happy
want to show
review
you
it.
anything. I'm asking you as a testifying witness for this jury, did you look at her medical records?
I did.
And the medical records pertain to her being a person that just had a baby, right?
I'm not sure that which records you're talking about, but when can I finish? Can I finish? Can I?
You're not going to finish. 2022, obviously, because we already talked about the summer. She was fine.
We're advocates for inclusion of the syndrome of postpartum psychosis.
And they've been trying
Describe
real
it.
hard.
Let him finish.
Well, he's just going to go on for another half hour.
I'll finish, Doctor. Go ahead.
I don't have anything more, sorry.
All right, go ahead.
And Lindsay's lawyer wasn't just all, full of energy and anger. He actually got down to the brass tacks and the facts about the illness that they're talking about. He also emphasized that postpartum psychosis is not currently listed as its own standalone diagnosis in the DSM-5. DSM-5, for anybody who doesn't know, is this big honking book that would break your toe if you dropped it. And it is legally what people need to use in court in order to, categorize and quantify the mental illnesses that they want to assess in any kind of case. It's basically the Bible of mental afflictions. And it changes a lot, hence 5. When I was at Court TV, I think it was the DSM 3 or 4. Now we're at 5. Thank God it changes because we are an evolving society and we learn more as we go. And Lindsay's lawyer also challenged Dr. Mack's interpretation of Lindsay's medical history. So that's a lot of stuff, right? Imagine being this jury. They now have to decide which of these experts' interpretation fits the evidence, which one they believe more. Basically, which one settles their gut a little better. They don't leave their common sense at the door when they go in to deliberate. They take their common sense with them, and then it applies. Was Lindsay's lack of a documented psychotic history proof that the alleged voice never existed? Or does it show how effectively she concealed the most disturbing parts of her mental illness, her psychosis, if she had it? Does carrying out several acts in a sequence demonstrate organization and control? Or could somebody acting under a delusion still behave methodically? Do the words go to God prove that Lindsay understood that she was doing something wrong? Or did it prove that she was doing something right, in her opinion? Do those words support the defense's claim that she believed she was sending her children somewhere better, somewhere safer? Altruistic filicide. I promised you, and I will not go back on my promise, joining me to break down this battle of the experts, what the prosecution accomplished on cross-examination, and what this jury will actually be required to decide in just a few days, is former Orange County prosecutor Matt Murphy. He literally wrote the book on murder. It's called The Book of Murder. Highly recommend you take a look, because not only does it tell you a lot about what a homicide prosecutor does, because that's what he did, but it also is like super personal. He takes you right into crime scenes. He used to go. As a prosecutor, he would go under the yellow tape and he would go to these murder scenes. So his book is about that, and it's actually pretty cool to read him, his thoughts as he's walking through these murder scenes and figuring out what he's going to do to prosecute. He also teams up with another friend of the show, Mark Garagos. They've got a podcast called In the Well. So make sure you check out both of those things. And here is our conversation about the very, very difficult task ahead for the jury in the Lindsay Clancy case once they've heard the closing arguments. I do not personally have a cat, but I know that many of you do. And if your cat runs the house the way most cats do, then you already know. They're not just pets. They are tiny little dictators with whiskers. And if you're going to serve your little ruler dinner every night, it probably shouldn't be a bowl of processed mystery meat. And that is where Smalls comes in. Smalls makes fresh cat food with protein-packed recipes, preservative-free, 100% human-grade ingredients, the kind you would actually recognize from your own fridge. I don't have a cat, but Lindsay does, and her cat's super picky and loves this food. And apparently, Lindsay says the fur's way softer, so win-win. And cat parents are noticing all the difference too. After switching to Smalls, 88% reported overall health improvements like better digestion, more energy, the softer coats, shinier fur, fewer hairballs, and yes, even less stinky litter boxes. So try Smalls and give your cat some food that actually looks like food. For a limited time, because you are a Drop Dead Serious listener, you get 60% off your first order, plus free shipping and free treats for life when you head to smalls.com/DDS. That's 60% off your first order, plus free shipping and free treats for life when you head to smalls.com/DDS. Matt, thank you so much for being on Drop Dead Serious.
Happy to be here.
Let's talk Lindsay Clancy, because this thing's coming down the pike. I feel like there's nothing that anyone can prove anymore except for those really strong closings.
Well, I think we can expect a really strong closing from the defense. The opening statements were he was very, very good, Mr. Reddington. That's a very experienced, talented trial lawyer at work. The prosecutors, however, during their opening, they're really relying pretty heavily on their notes. And on an emotional case like this, you can't match that low tone of the defense lawyer with sort of wonky technical stuff. So I mean, we'll have to see what happens. But right now, from what I've seen, and I want to be fair to the prosecutors, but they've been apparently so far they've been really outmatched in the art of trial work.
The art. I'm so glad you said that, because all my years on court TV, I sat beside Jack Ford, and always during the commercial breaks, I'd get this incredible tutorial. And one of the things he used to say to me all the time was, it's a performance in there. Make no mistake. Lawyers have to perform, and they have to endear themselves to the jury. They may have a great case, and they may be shitty people and really bad communicators, and that can lose it.
It happens all the time. In the true crime world, most of the time we're watching evenly matched attorneys, or you're watching good attorneys on both sides, and it's very easy to forget that the vast majority of cases, and this applies to everybody. When misdemeanor cases, for example, they typically don't televise too many of those, and that's when lawyers are really learning the craft, and it's a craft. There's some really hyper technical rules on the rules of evidence and where to stand in a courtroom and all that sort of thing. Everything beyond that is the craft of trial work, and it's exactly what you said. It's about vibes and which juror is responding to your stupid jokes, and I mean my stupid jokes. Other people's jokes aren't stupid, but who you're vibing with. Not to get too Californian with you, but that's really what trial work is. It's sort of being able to read prospective jurors being able to read the courtroom, understanding what the judge wants, understanding what a juror would want to hear to best get them to understand your case. And that's where the art really comes in. And some of that is skill, and some of it it's more life experience, if that makes sense. So in Kevin
Or your
Reddington, you
character, right? Like who you are. I do this for a living because I was always good at
whether
talking.
they believe you.
Right.
And look, when it comes to like forensic evidence, like DNA or things like that, a lot of times it can get very, very technical. But juries, especially when you look at a jury, it's about 500 collective years of life. 12 jurors will, on average, have lived about half a millennium, and that's the strength of the jury, or the jury system. It's the idea that you've got that members of the community, and as an entity, for lack of a better term, that's a really wise thing. Imagine if you had a person that was 500 years old, like they would have seen it all. That's a jury at its best. And if they get lost in the technical stuff, I'll tell you, they never get lost on who they believe or who they like or who they think that they can trust. And that applies to every single jury trial. And as a trial lawyer, you learn pretty early that it really is a contest of credibility between you and opposing counsel.
So that should also extend to your experts, because I have seen experts on the stand who are dry and arcane and not very likable. And when it's a battle of the experts, it's the same gut that has to take, all the expert testimony in on both sides.
That's right. And look, one of the things about forensic experts, especially forensic psychologists, like we've seen in this case, there are some really good ones out there, but by and large, again, I want to be fair, they're hired guns. A lot of people think that there's like this, we almost get this sense like there's like a repository of experts that just sit there to, waiting for the issue to land on their desk where they can objectively apply the science and like come in and wait. That's not reality. A lot of forensic psychologists in particular, over the course of my career, I spent a career cross-examining them. A lot of them honestly are full of shit. They get paid. They want to get paid by the next lawyer. And I mean, I can't tell you how many of them I have cross-examined that were really very mercenary, I believe, in their opinions.
Wow.
So, this case, I don't think this jury, honestly, Ashleigh, is going to base their verdict on what we heard from the experts. I think that the people that will probably have the biggest impact are the grandmothers. And I think like the sister and even, the husband. I think that the jury is going to be very good at assessing what happened on a really common sense playing field, if that makes sense. Another thing to keep in mind is when you're talking about Massachusetts uses what's known as the McCool rule. Okay, almost every state in America uses what's known as the McNaughton rule. The McNaughton rule for insanity is what we use in California, and I've done a bunch of murders where insanity was the defense. And essentially the way it works is this: if a person, due to a mental illness or some sort of delusionary issue, something in the DSM, some sort of mental defect or mental illness, if they do not recognize the nature and quality of their actions, then they are legally insane in the state of California and every other state that uses the McNaughton rule.
Don't they have to also not understand right from wrong under McNaughton?
Right from wrong is really more it's a thing for juveniles, but basically, if they understand the nature and quality of acts, yeah, look, that's a very probably a cleaner, more simple way of looking at it. Do they understand right from wrong? So the example that we always used in explaining it to juries is we've got that old trope of the devil on your shoulder and the angel, right? The angel says don't do it, and the devil says do something bad. If the devil tells somebody who's suffering from mental illness, go over there and stab that banana, or go over there and stab that alien, or I'm going to blow up the world, and the person goes and kills somebody, because of that delusion, they do not understand the nature and quality of their actions. In other words, they don't understand that they're killing a person. Okay, you do the same thing, same scenario, the same devil on the shoulder says, hey, that that person over there, go kill that person over there, or I'm going to blow up the world. The person in that case is suffering from a delusion, but they still understand that that's a human being they're stabbing. So, on a legal and moral standpoint, what the McNaughton rule says is even though you're suffering from mental illness, and remember, almost every murder is committed by somebody who's suffering some sort of mental illness, right? Because
Sure.
people in their right minds don't kill each other typically.
Right.
So if they understand it's a human being, they understand that it is the nature and quality of their actions, and they are, even though they're suffering from mental illness, they're still legally sane for the purposes of criminal liability. Massachusetts does not use that rule. Under the McCool rule, there are 3 prongs. Number 1, are they suffering from a mental disease or defect? Number 2, based on that, are they, do they, to use your words, do they not understand right from wrong at all? They don't know what they're doing. They don't understand the wrongfulness of their actions. But there's a 3rd prong, and that is, even if they're mentally ill, and even if they do understand right from wrong, are they able to control their behavior to conform to the requirements of what is expected of them under the law? So there's a 3rd prong. And another thing to keep in mind about Massachusetts is the way it works in California or everywhere else, we bifurcate murder trials where insanity is a defense. What that means is you have the guilt phase where you present evidence, and then once the person is convicted, then you go into what's known as the sanity phase, where that's where you get the psychological information and the experts will come in and you have your battle of the experts and all that. The defense in California bears the burden of convincing the jury. They bear the burden of convincing the jury that the person does not understand the nature and quality of their actions. Okay. In Massachusetts, as soon as the defense establishes a prima facie case, or even just basically a scintilla of evidence that the person is suffering from a mental disease or defect that may affect their ability to substantially appreciate the wrongfulness of their conduct, using some of the language from Massachusetts, the burden shifts right back to the prosecutor to prove that the person couldn't do it or could do it. Okay, so it's probably the strictest standard legally in the United States under the McCool rule, and these from the very beginning. I think that this case has been about the facts and the law far more than it's going to be about the experts, if that makes sense.
That is a lot to ask 12 people who came into a courtroom as hairstylists and mechanics and delivery people and, and the guy who runs the bodega. I mean, that's a lot to ask of them. So then does it behoove the prosecutor and the defense attorney to make it make sense in the closings, or is it up to the judge? When the judge reads those jury instructions, they are so dry and they are so technical and they sound like law school, and it's too much for the average person.
Well, again, we're back to the art. Your job as a prosecutor, and I had an old mentor, Chris Evans, who used to say, never give the law short shrift. Take your time explaining the law. So the way you do this properly is you, as the prosecutor, you almost do your opening argument is essentially 2 parts. One is you're explaining the law to them, and you're doing it in a way that it makes sense. You're doing it in a way that you're explaining the concepts with the letter of the law right up there, like, ladies and gentlemen, what does this mean? And, like, for example, reasonable doubt. Okay, the definition of reasonable doubt, the one that we use in California, is proof to an abiding conviction. So because our law is based on what came before, what's known as stare decisis, things that have happened, or things that have already been decided, it's Latin, but it's basically we build on cases of the past, including
Precedent,
the language
right?
that we use.
Precedent.
Yeah, precedent. So 150 years ago, when they were writing those laws down, our day-to-day language might be abiding conviction. Now we really don't use those words the same. So you have to explain, what does abiding mean? Abiding means something stays with you. Conviction means that based on your common sense, your life experience, listening to the evidence, you believe the person did it. And you believe it strongly enough that it stays with you. It's abiding. So in a week, a month, a year, you can look yourself in the mirror, in the eye, and say, you know what, I thought he did it then. I still think he did it. That's what proof beyond a reasonable doubt means. Okay, so it's taking kind of these old
I'm not
words.
deciding on a whim today. Yeah.
Right. But it's taking that language and explaining it to them in a way that they can understand. So if you're a mechanic or whatever, and simply because somebody's a mechanic, like, these concepts aren't out of reach. It's making them and some of the smartest people I've ever known have been mechanics,
And I don't mean
and
for a minute that they're
hairstylists
not,
too.
but what you just said is exactly what I mean. We don't understand other people's business in their terminology. So it's the job
Right.
of those litigators to take that very technical language and make it make sense, make it common parlance. And some of them do it well and some of them don't do it at all.
Right. And I think that what we can expect here is that the defense lawyer is going to do a very good job of that. His opening statement actually was excellent. He spoke in low tones. If you look at him closely, you'll see his eyes are moving. He's looking every juror in the eyes as he's talking. And it was excellent. The prosecutor, in contrast, and again, I want to be fair, they've got a tough job. I've been there. She was kind of
Checking
stuck on
boxes.
the she was stuck on the podium and she was reading from her notes. And every time you take your eyes off the jury to look at your notes, you lose the jury. And that's trial tactics. That is, and it's the pressure's intense, and you're up there, and everybody has good days and bad days, in court. But they were not equally matched, in my opinion, in opening. And I have a feeling that the closing is going to be even more intense.
Let me ask.
Kevin Regnson is going to get up there, and I think he's going to do. My guess is he's going to do a very persuasive sort of man of the street closing argument. And I think that the prosecutors, maybe they'll step up, but this is one where I really think they've been outmatched by the defense attorney.
I sometimes call it Jose Baez style because I feel like in the Casey Anthony trial, his command of this jury was like a performance. It was theater every single day. Meanwhile, the
Yeah.
prosecutors were taking through a case they'd put together for a couple of years. Not a good one, in my opinion, but, and I think they liked Jose Baez. But let me ask you about what they will use from the battle of the experts. Because I'll be honest with you, as I look at the experts, they both said two different things, as they do in every case that has a battle of the experts. And I don't get it. You're both doctors, you both studied, you both got, approved by your various boards, and yet you come through with completely different opinions, which terrifies the hell out of me about going to a therapist. But Dr. Resnick, who was the defense expert, used language, and I want to read it for you because when he was on the stand saying it, I'm like, oh, snap. He literally used the language of law. He said, in his opinion, Lindsay's mental illness left her unable to conform her conduct to the requirements of the law. Wasn't that your third prong there?
Yeah, and by the way, that's totally improper for a psychiatrist to do that. They do not. A psychiatrist or a psychologist or a defense expert should never ever be instructing the jurors regarding legal issues. And the prosecution, if I was in the prosecution on that case, I would have been down his friggin' throat. And I mean,
They weren't.
a lot of people would have been. And you can't do that. You
They
can't
didn't
do it in
object.
California. You can't do it. You can't do it in Massachusetts. And look, he also, another thing about his testimony, Ashley, and I don't mean to interrupt you, but he said she had no idea what she was doing at all. And it's like, really, dude? Yeah. And you don't have to do that. The law doesn't require that. She can know that what she's doing is wrong in Massachusetts, but the question is whether she could conform her conduct to comply with what the law required. That is the crux of the issue. And I thought they went very, very hard. Look, I have colleagues, Ashley, from the old homicide unit, some of the people I worked with, they would still have that guy on the stand after that testimony. I was unimpressed with him. And look, I'm going to call the shot here. I think this jury is going to go with the defense. I think that's what's ultimately going to happen
Why do
here.
you think that? Because of the lawyering?
No, I think that first and foremost, it's the fact that postpartum. It's important to remember there's postpartum depression and there's postpartum psychosis. Those are different things.
Very
And
huge,
postpartum
massive,
depression is
massive.
very, very common.
It's actually the
Postpartum
question here, isn't it?
psychosis.
Isn't this really the question? Everyone knows about postpartum depression. Almost nobody knows about postpartum psychosis unless they've had
Right.
some experience close to them or somebody they know, or they've been through it themselves. And isn't this really so much the crux here?
Yes, it's the crux, and and clearly she knew what she was doing. At least to the extent she did the search to find out how long he was going to be gone. She sent him out. Like her actions are deliberate. She's not howling at the moon. Under Massachusetts law, that's okay for the defense. So I almost wonder if he went, if he went too far, too strong, it's not going to make a difference on the verdict. But look, she's suffering from severe mental illness. And by the way, in California or any other McNaughton rule state, the difference between depression and psychosis is huge, because you're suffering from psychosis might mean you do not understand the nature and quality of your acts. Depression doesn't. Somebody who's depressed, this could be a murder suicide where they are killing themselves and decide to take their kids with them. That's a different thing than psychosis, where they truly do not understand what they're doing. But in Massachusetts, it doesn't matter. It's can she conform her conduct? And that is where I think the defense is going to lean very heavily on. If you only need a 2, don't blow the whole case because you're going for a 10, if that makes sense. And I was unimpressed with him, to be honest. And honestly, Ashleigh, I was watching some of that testimony, kind of pacing around in my computer screen, wanting to jump in the game, because there was a lot of vulnerability there. I do not think the prosecutors took full advantage of some of the things that he said. I was less impressed with their cross-examination. And of course, there's an old adage: the older I get, the better I was. It's easy for me to Monday morning quarterback any other lawyer.
When you're standing in the well, right?
Yeah, that's right.
He also at one point used the language saying that she was unable to appreciate that her actions were wrong, which again sounded like he was quoting law to help, his hired attorney, the defense attorney, along in the case. So does the defense attorney then take his words and re-quote them to the jury, or does that start to sound like you're protesting too much?
No, the defense, look, on that one, from my view, my opinion, Reddington got away with murder on that. Sorry, excuse the pun. Like, having an expert instruct the jury as to law, again, totally improper to do that, guys. You can't do that. And the prosecution should have been out of their chairs, and they weren't.
Yeah, they weren't.
So a psychological expert, whether they're a psychiatrist or a psychologist, can come in and testify to their diagnosis. They can testify to the mental illness of the defendant. They can explain what that mental illness means. It's the judge and the lawyer's job to take those facts and that opinion and have it apply to the law.
Right.
A psychiatrist leaning over and telling the jury in legal language, like
almost code, right? He's quoting legal procedure and code.
There are judges in Orange County, Ashleigh, and in LA that I've appeared in front of that would have been friggin' ripping that guy in front of the jury. You're not supposed to do that. And look, there's a lot of emotion swirling around this case. This is real. It's horribly tragic. You get 3 little children that are dead here, and the process should proceed to the right place without anybody pushing the limits of what's fair and unfair. I think that testimony was unfair. I would like to cross-examine him, although the ending here, where she is found under Massachusetts law, and I think I think the jury is going to find for the defense. Just my guess, and I think that's. I can't on this one. Like, I understand why they're going to reach that. And look, we had a murder in very similar case in Orange County about 30 years ago now. A former colleague of mine named Jeff Robinson, who's in the homicide unit. This guy was as hard charging a prosecutor as ever existed, and he was a uniquely talented trial lawyer, to the point that he'd get himself in trouble. He was a phenomenal prosecutor. And he had one very similar with a woman who was on Prozac, who murdered her 2 children. And Jeff was undefeated. I don't know if Jeff ever lost a case, which is insane.
Yeah.
And he reviewed the case and got into Prozac and did a deep dive, as prosecutors are supposed to, and really wrestled with it and went to the powers that be, the elected district attorney, and said, "Look, I've wrestled with this. I've researched it. I believe that this was a combination of postpartum and Prozac." And they dealt that case. I don't remember the exact dispo, but they dismissed the murder charges against her.
How often does that happen?
Never, almost never. But look, that is the role of a prosecutor. A prosecutor's job isn't to rack up wins. The job is to do justice. The prosecutor's job, you got to keep an open mind. You have to do justice based on the evidence. And look, I've had cases that you hear a piece of evidence in the middle, where it's like, where as a prosecutor, if you're doing it right, you have a fair and open mind, and I've had that happen where it's like, we got to talk about this, and we've dealt cases in the middle based on evidence that
Really?
that came out a certain way. Yeah, I've had that happen twice. Both times I gave the defense lawyer a bunch of crap. It's just like, dude, why didn't you tell me about that? And we didn't have to pick the jury.
We didn't have to go through
Like,
all this. Waste all
we
this
didn't have
money,
to go through all
time,
that. And
pain.
the answer is they wanted their freaking trial win or whatever. But well, I'll take that back.
Or billable hours,
I'm
maybe.
sure
Who
it
knows,
wasn't that they just wanted their trial win, Ashleigh. Look, this jury is going to. I think they're gonna find for the defense. And I think that,
Tell me, is it emotion or is it great litigating on the part of the defense?
no, I think it's the facts and the law. Massachusetts law. It's almost as if it was written for the facts of the Lindsay Clancy case. I think that they will. I think that her mother testified, in a way that the entire jury can relate to. I think that her sister was also really good. I think that that Lindsay Clancy's former mother-in-law, the famous question about, isn't that a mortal sin that we all watch, which is also improper. But I thought she came off very good too, and she testified for the defense.
And
So I think
Patrick,
that when
the husband.
look, I'm not I'm not a super fan of that guy. One of the crazy things on this case, Ashley, that we've seen are all the conspiracy theories and all that, and here are all the reasons why he did it. He didn't kill the kids, guys.
He did
She
not.
killed the kids.
He didn't get married 7 days after the kids were killed.
Yeah.
All these bullshit things that are all over the internet. No,
The
he's
thing is,
backed her.
and it's okay. It's okay to dislike somebody without he doesn't have to have killed the kids not to like, or it doesn't have to have committed the murders not to to not like him. There's plenty of other reasons why I could see objectively. He got married pretty soon, and he did a hike in Central America and posted that apparently. But that people deal with grief differently. I don't know.
And also, P.S., give the guy some grace. His children were murdered by his wife. Come on.
Yeah.
Let him be.
Yeah. Well, yes.
I should take that back.
So-
His children were killed by his wife. I can't say murdered.
Right. And I think the jury's going to find that she was not criminally responsible. That's my guess. But I've been wrong before. I don't think I am here. But
And let me ask
look,
you
a
this,
lot of the
because this, I think, is a big fear of guys like you, prosecutors. If there were a case that were ripe for nullification, even if they felt that the prosecutors had proven that this was a murder and in their gut they felt sick about it, they looked across at her, they felt for her, they either have some knowledge of postpartum depression and psychosis or the myriad different, illnesses that fall in between, and just decided, I'm not putting her away. I'm not. They nullify. Do you think this is one of those cases that could happen?
they don't have to nullify here. It's a great question. Jury nullification, in my mind, is like the law and the elements are clearly there. Like the adage that a lot of judges give is, you got a little old lady that's feeding the pigeons, and there's a sign there that says no feeding the pigeons. And if there's 10 videos and the police officer and a confession, yes, I was feeding the pigeons, but the nice old lady's feeding the pigeons, a juror coming in and going, who cares?
Yeah.
That's jury nullification, where all the elements are there,
Perfectly
the evidence
proven.
is there,
100%
but they
there.
nullify, which is it's not supposed to work that way. Jury nullification, it's the judge's job to determine the most appropriate sentencing, but that's jury nullification. Here, the jury doesn't need to nullify. Here, the jury just needs to follow Massachusetts law and make a determination that even if she understood the right and wrong, she couldn't conform her conduct to what was required under the law because of her mental illness. That's the end of the ballgame in
Matt, I don't know.
Massachusetts.
I did not expect this from you. I really didn't. I get it, but I feel like some of the things that the medical experts brought on the stand by the prosecutor said really were very powerful. I did not see psychosis. I did not see her rise to the level. She was methodical. Yes, the defense expert said you can be methodical and be in psychosis all at the same time. But I thought that they did have some strong, points to make. And you never know what lands with a juror or 2 or 12.
No, that's exactly right. And look, we're also talking about, let's not forget, we're talking about strangulation. Strangulation is not like TV. Ashley, we've all seen that scene in the movies where somebody puts their hands on somebody's neck and they're dead 10 seconds later. Strangulation for an adult female takes between 5 and 7 minutes to achieve brain death. Okay, that is an eternity. If you look at a clock, now with an infant or little kids, I'm sure it's probably less time, but it takes forever. What I think, an opportunity I think the prosecution missed here is, you know, I think, and this is again Monday morning quarterbacking, but the way I think to approach this is, yes, she's got all these problems. Yes, this is all legitimate. Yes, she really is suffering from she was let down by the mental health system. She was let down by her own psychiatrist. I heard the term tackle box of medications like 13. All of that is true. Yes, yes, yes. However, when her husband finds her at the base of that window, she doesn't say anything about the children. She says the kids are in the basement, but she never tips him off that they are in medical distress. She doesn't say I hurt the kids. That is, you know, that's the time to wake up. And I know I've heard all the stuff, but the EMTs got there 6 minutes later, and they said that she was just moaning. He testified, the husband testified that she was communicating with him, and a lot of that was also I don't think you could hear her voice. I could be wrong about that, but he's giving a play-by-play to the 911 dispatcher. And that's, you remember the infant lived for like 3 days. So that infant is still alive down there as she's talking about how she tried to kill herself. That is where I think the prosecution should have built their case. They didn't. And, you know, so look, a lot of this
She's
is facts, a lot of
delusional
it
and
is law,
psychotic.
a lot of it is
What
tactics.
would it matter what she said while she's lying there bleeding, paralyzed?
Because I think the argument is she still had the opportunity to save that one kid, the infant. I forgot the infant's name. I'm sorry.
Yeah, Callan, I think she thought she already had by killing him, you know? That's the psychosis.
Yeah, well, that's true, and she wouldn't. Yeah, that's true, and she wouldn't know. But that's a far more interesting. I would like to see that. I'd like to see Kevin Reddington have to explain that more than what he's going to have to do. And I just. Yeah, this is.
Let me ask you something about the way jurors are. You're not allowed to say certain things and explain certain things to them. Like, you're not allowed to say to them, hey, if you decide to find her not guilty by reason of insanity, she doesn't get to walk out the back door. Here's what's going to happen to her. You're not allowed to really explain the sentence or explain the consequences. And
Right.
for a lot of them, they can't get over saying not guilty. But if they knew more about it, if they knew it meant, no, she'll go out the side door, she'll go right into an institution, and she will not come out till she's better. And Andrea Yates still isn't out a quarter century later. Why don't we explain more about that to make these decisions easier on juries?
So it's a very good question. And the answer is everybody in a courtroom has their role. Everybody has a lane. The court reporter's job is to record everything that is being said. The bailiff's job is to ensure security. The court clerk keeps those courts running as far as organizing the exhibits and everything else in a trial. The judge's job is to consider sympathy, and the judge's job is to consider sentencing. And as soon as you have a jury that is considering sympathy or something like that, they are now in the judge's lane. And that's where it's like the judge telling the jury who they have to believe or not believe. That would be the judge stepping out of the judge's lane into the jury box. So our system only works when everybody sticks to what they're supposed to do. And so if we were to tell them, hey, here's the sentencing range, the only time a jury, like in California, and every state is a little bit different on this, the only time a jury considers sentencing is in death penalty cases.
Death penalty, yeah, because they know what's
Right.
going on. They had to be death qualified.
Right, and even then, they're instructed it's either life without possibility of parole or death. Although there's a big movement in California right now, my fair state, to eliminate life without possibility of parole, which that's a separate issue for a separate day.
A whole
that
other
you can watch
podcast.
me rant on. So the answer is you don't. The jury has to determine. They have to make credibility calls, and they have to make factual determinations, and then they have to apply the law. That's their thing. Sentencing and what happens afterwards, that's the judge's job in the state of Massachusetts for a case like this. So it would make it easier for the jury, but we can't do that. We
I
can't
have a
do it
solution.
that way.
Some states, I can't remember which, but again, this was Jeff Ford's tutelage. Some states have a terminology of code that says guilty but insane, which is so easy because now you don't feel so bad about saying,
That's right.
guilty
That's right.
but insane.
That's right. And it's also interesting because you have you've got, like in California, it's sanity's bifurcated. So there's a psychological sort of component of it where a jury has already voted guilty on that person. They know that there is some consequence that is going to befall them, whether they find them insane or not. So in the sanity phase. So this one is look. She was suffering from legitimate mental illness. I think that evidence is very strong on that. And then once you throw in Massachusetts law and a lawyer as skilled as Kevin Reddington, yeah, like I said, I think this is looking pretty good for her. Now, that said, remember she's in a wheelchair. She's gonna pay a consequence. Somebody told me that she's talking about wanting to do like a wheelchair marathon and all that. Like I don't know.
She's got goals, and some of them are pretty altruistic too. Wants to work to help people understand postpartum issues. I get it. That is something I want to ask you about, the getting out factor. Andrea Yates never wants to get out. Her lawyers have visited her regularly in the 25 years since her killings of her 5 kids. She does not want to get out. She wants to stay where she is. Most people, I'm not sure, like that. Is it possible for Lindsay Clancy to get out in a year or 6 months?
Yes, I don't know about 6 months. And in fairness, I'm not an expert on Massachusetts law for their criminal commitments for findings of what we would call insanity. There, it's not, the language is a little different, not criminally responsible. But yeah, look, we have, that happens quite a bit. There was a case at Santa Barbara, again, different system, kind of, where there was a guy at my old alma mater, spoiled kid from Santa Monica with rich parents who had a bad night and drove his car down one of the streets and killed a bunch of UCSB college students in his car. Mm-hmm. And that was tried by a friend of mine, Jack Early, and they convicted him in the guilt phase, and then they found him insane, and he went to a hospital. I think it was like 4 years, and I might be wrong on the time, but he's out now, and that was a that's a very common thing, because when somebody is truly, truly insane, right, they will go up to Patton State Mental Hospital here in California, or whatever the place is, Bellevue, I guess, in New York, I don't know, and they'll stay there sometimes for the rest of their life, because they're not going to get better. For something like postpartum, she's already going to be of a sound mind at this stage. Maybe they get the medications right. Maybe she's not on any medications
hey,
now.
Matt, since the killings, she is not reported hearing the voices of the hallucinations. So she's almost like that was some catharsis of some kind, and she is getting better, and she's got life goals. I mean, she's already showing that she's better, and her expert has said that. Her medical expert has said that is what happens.
Yeah, so she would definitely get out. I don't know how long they keep her in Massachusetts, but at some point, could be a year.
And by the way,
4 years.
That's not an easy process, right? Like, can you help the listeners and the viewers to know, like, it takes a lot of doctors and a lot of assessments and a lot of paperwork, and they have to confer, right, with the prosecutors as well. Like, there's a system. It's not just,
no, they don't.
She's doing all right, check her out today.
Yeah, they don't confer with the prosecution.
Ever?
No, at least not in California. We're never notified. Somebody goes up. They march to the beat of their own drummer.
Wait a minute, that's unfair to the victim's family and friends and those out who need to know. Hey, this person's getting out. John Hinckley's getting out. Like, I thought that the prosecutors had to know so that they could at least weigh in and make sure that the due diligence was done at the hospital.
Yeah, they may notify. Hey, this person's getting out, but the prosecutors are not consulted. Now, there are depending on the kind of case. There are circumstances where the prosecution can be invited to oppose it. There was a famous mass shooter in Fullerton that went to Cal State Fullerton, shot from a bell tower sort of thing, and shot a bunch of kids in the 70s. And that was one that our office opposed every time. But a lot of times, they will, and it varies from state to state. Ashleigh, not every state and not every case will the prosecution have an opportunity to weigh in. Now, if you are in California, we're getting a little in the weeds, but you also have what are known as sexual violent predator designations, where somebody who runs out of criminal time can then be transferred to a mental health facility, because but they don't want to let them out. But even those guys tend to get out eventually. So
It's a
it all
fascinating
depends on
science.
the circumstances, the kind of case it is, and the state.
And like mental illness, it's remarkable how little we really know about criminal procedure when it comes to these kinds of cases and what actually happens. And it would be really nice to know that more jurors understood a little bit about the mental illness that they're about to adjudicate. And then also that it doesn't mean they're walking out the back door. It means that there's a whole other process that is appropriate. But that's a whole other podcast too. Matt, I hope you feel better. I don't know if everybody knows, but Matt did this even though he's feeling really sick. So I really appreciate it.
No, thanks, Ashley. No, for the viewer, I was supposed to be on a dive boat, and I came down with, I got a little sniffle, and I got one of the COVID tests just to be sure because I was going to be in a confined area, and sure enough, I tested positive for COVID. So running a little fever. So please forgive me on my
Little known fact.
many rants.
Little known fact, 1991, I was traveling with a backpack all around the world, and one of the stops was supposed to be 6 days in Airlie Beach, Australia, for a dive PADI course. I was going to get certified, and my boyfriend at the time also, we were going to get certified. And he had like a break in his spine originally from a construction accident, and the doctors red flagged him and said, nope, you've got probably some kind of scar tissue in your spine, and we can't flag you for diving. So there went my dive instruction for life. I never learned to dive.
Well, it's not too late. It's not too late.
No, it's just a time thing. But you know what I did do, Matt? You know what I did on those 6 days? I chartered a keel boat in the Whitsunday Islands, and I captained it. And the things that I learned while captaining that yacht, I applied to the case in the Bahamas, Lynette Hooker. So it all came full circle, and it was all a benefit.
I love it. The Whitsundays are beautiful. They have dingoes in the Whitsundays too, I think, right?
They
those
do.
dogs. Yeah,
and the
yeah.
most beautiful beaches in the world, I highly recommend it. Boy,
And some big
did we
sharks.
ever take a
Yeah, big
right
sharks
turn
there.
on this podcast? Matt, thank you. I hope you get your dive trip in later.
Thank you, Ashley.
My great thanks to Matt Murphy. He always explains things. And here I am decades into this job, and I still learn new things. I think that's something we can apply to life. You always learn something new every day, even when you don't think you can. I'm really curious about how long you think this jury is going to deliberate once the closings happen. And they're scheduled for next week. I'm recording this on Saturday, August the 22nd. But I mean, to be a fly on the wall, right? Follow them, follow behind them as they walk in and the door closes, and it's just them. Trust me, there's nobody in there helping them through it. There's no court clerk or judge or bailiff or anything. I mean, they can knock and say, I need food, I have a question for the judge, we need a break, whatever, or we've got a verdict. But they're by themselves in there, and they have to figure it out. Bunch of lay people suddenly with someone's life in their hands. If you've never been on a jury, do it. It's amazing. And this kind of an experience is the amazingest. But how long do you think it's going to take them to come up with a decision? Is it possible they might hang and be so split they won't have a decision? So again, pop them in the comments. I love hearing where you guys stand on this. You know pretty much where I stand. I usually try to be open to both sides, but in certain cases, I definitely feel a certain way. And in this one, I feel a little like Matt. Like, I think this is going to be a case that goes to Lindsay Clancy, not the prosecutors. But you never know. I thought that about OJ. I thought the prosecutors had it. Go figure. So I tend not to try to call them anymore. Thank you guys so much for listening. Thank you for watching. I so appreciate you. If you haven't already subscribed, please do. It does me a huge solid, and it's free. And also love if you join the membership too. We got a great group of members, and we do all sorts of fun events together. Be a part of it. Thanks again. And remember, truth isn't just serious. It's drop dead serious.